Good morning. I'm Patrice Looby, Nurse Case Manager here at PERAC. And today's presentation is regarding accidental disability retirement medical panels and reasons for remands. Next slide. I'll be discussing the medical panel phase of disability retirement applications, specifically accidental disability, and Ken Hill, Assistant Deputy Director, will be discussing the reasons for remands of accidental disability retirement. We hope that our presentation today covers everything you want to know about these topics, but if we miss something, jot down your questions and we will be happy to address them as we move along in the presentation. So I'm going to briefly review the types of disability retirement. The first one is ordinary disability, and that's generally a disabling condition which has no relationship with the applicant's job duties. The second is accidental disability, which is a permanently disabling condition, which was caused by a specific injury or hazard caused by the nature of the applicant's employment. Our processes and procedures are mandated. Whoop, you went ahead too fast.
Sorry,
go back one.
sorry.
Okay. Our processes and procedures are mandated by Chapter 32 and Disability Regulations 840 CMR Section 10. They're formulated to ensure a fair and equitable process, and I will be discussing Sections 6 and 7. The medical panel unit at PERAC's role is to determine, based on the information provided, that the medical panel can be convened, appoint the appropriate physicians to examine the applicant, and provide a usable medical report to the retirement board. We hope that you will see us at PERAC as a resource to assist you in navigating the process. Any of you that have gone through a disability retirement application will know that there's a lot of material to cover. In order to cover everything, I will go over the important factors and the common questions that arise during the process. So now I'm going to review types of disability retirement. Superannuation, or Section 5, is a benefit determined by age, years of service, salary, and group classification. Accidental, Section 7, is a benefit that is 72% of salary with no service requirement. Ordinary, Section 6, is a benefit is determined by age and salary with a minimum of 10 years and sometimes 15 years of service with a veteran factor. A common question we're asked is, can anybody apply for more than one? The answer varies between individuals, but generally, yes. The reason for this is approval for one does not preclude the others. Now, the application for disability retirement is a lengthy process. Next slide. So does the decision to seek disability impact retirement? And the answer is yes. Unlike superannuation, there are post-retirement requirements associated both with ordinary and accidental disability benefits. People need to be aware of these requirements. It may impact their decision. Next slide. So some post-disability retirements are found in General Law, Chapter 32, Sections 8 and 91A. While receiving disability retirement, the retiree is required to submit 91A earning statements yearly, provide updated medical information, and undergo exams. Many people call us to say, I don't know, we didn't know we had any earning limits. The panel told me that my disability is permanent. Why do I need to keep on sending medical information? Both of these requirements are an important factor for these retirees, and they need to be aware of them. Well, I suspect that the applicant forgets that they were told about these issues at the time they met with the board. Some of the most common questions we receive at PERAC are about these post-retirement requirements. Next slide. So what are the eligibility requirements for disability retirement? Specifically, Sections 6 and 7. What are their differences? Well, ordinary, Section 6, generally is a fairly catastrophic medical condition that prevents an employee from performing their job without a connection to their employment. Accidental, which is Section 7, is a medical condition that prevents an employee from performing the essential duties of their job with a causal connection, like an accident that occurred while they were working, like our laborer here. Again, for the ordinary, there is a minimum 10-year requirement. For the accidental, there are no minimal service requirements. Next slide. So let's talk about the application process. How does somebody apply? First, a member of a retirement system contacts the retirement board. The retirement board is going to counsel the member and provide him or her with an application for them to complete. The retirement board needs to submit a treating physician statement to the applicant's doctor. They need to submit an employer's statement to the employer and collect medical records. This is generally the longest part of the process. Applicants should be informed that the entire process will take months to complete, and they should plan for this. As I discussed earlier, this may be a situation in which the applicant would apply for superannuation if they don't have adequate sick time to provide income while in this process. So what does the application contain? It contains the member application, which includes an employment history, and medical release forms that are signed by the member so the retirement board can collect their medical information. It includes a treating physician statement, which supports the application, and it must answer 3 specific questions, which I will cover, I'll discuss further. It includes an employer statement, including the job description and injury reports, and the medical information for the last 5 years. So PERAC requests the above documents be available prior to convening a medical panel. The major reasons for delays in the process is that some portion of the above information is not available to the panel when they examine the applicant. Next slide. Here's an example of the required forms for each type of application. I'm not going to go through these today, but this is available for your use at the board. Next slide. So what are the medical requirements for disability retirement? Both the treating physician and a majority of the 3-member panel must find that the applicant is mentally or physically incapable of performing the essential duties of their position, and the incapacity is likely to be permanent. In the case of the application for accidental disability, the physicians must also find yes to question 3, which is the said incapacity is such as might be the natural and proximate result of the personal injury sustained or hazard undergone on account of which retirement is claimed. In order to appoint a panel for accidental, we required this document first. This part of the application, if this part of the application is not completed, you'll be hearing from us. Now, just a note on permanency. Permanency is not what you may think. You may consider permanent to mean lifelong, which is generally the accepted meaning. However, the standard for permanency, as it applies to disability retirement, is it cannot be determined when it will end. This is very different from the lifelong meaning, the reason for many questions from retirees about this. So now we've discussed service and medical requirements. Next slide. But what about an involuntary application, which is Section 16? Where does that fit in? So I'm going to discuss the similarities and the differences. When the member or applicant files the application for disability, we refer to this as a voluntary application. The employee files the application and provides the necessary medical records, etc. In the case of an involuntary application, the employer files the application. There is no treating physician statement, and the employee is not required to supply medical records. We ask the board to provide us with a medical summary from the records so that we can make a specialty determination. PERAC handles the medical panel process the same as if the application is for the voluntary. So the impact of the voluntary is the panel physicians will only have what is available to the employer, such as workers' comp records, 111F, medical examinations, etc. Because of the possibility of an incomplete medical record, there can be delays with these applications. Next slide. So now we're going to speak about presumptions, which is section 94, which is the heart presumption, 94A, the lung presumption, and 94B, the cancer presumption. The presumptions are available to police, firefighters, corrections officers, and some others. The heart presumption is available to all three. The lung and the cancer presumptions are available only to firefighters. The presumption is that the disabling condition is presumed to be caused by the job. The applicant must still be determined to be disabled while a member in service, and still the condition must be considered to be permanent. The cancer presumption has a 5-year window of discovery after the last date of service, but that's only for the cancer presumption. Now that we've discussed the types of retirement and eligibility requirements, let's discuss the medical records. Next slide. So once a member applies, the retirement board is collecting a lot of information. They're collecting the application from the member, the employer's statement, the job description, and medical records from the applicant's doctors, hospitals, therapists. It's a lot of information. So what do the retirement boards do with all this information? They need to compile it and organize it. So some questions we have from the retirement boards are, do we really have to copy all of this information? Now that we have Prosper, the board is only required to maintain one copy at the board and submit the medical records through Prosper. Now, physicians rely on these medical records in order to make their medical determinations. Medical that the board is requesting is for the last 5 years. Now, as non-medical people handling this information, it is important to note that you have to maintain confidentiality, and these documents must be contained in a secure area. So now it's time to organize for review. Now, I can't stress how important this is. If medicals are not available, appointments get canceled. If they're not organized, physicians may cancel the appointments. Physicians may not be able to identify important documents. This is a cumbersome job, but it's an important one. From the time of the member's application onward, the medical information is going to be reviewed by numerous people: the retirement board, attorneys, medical panel physicians, nurse case managers, and post-retirement physicians. So having the medical information organized is very important. One of the Prosper improvements to the medical panel process is that the boards can submit the medical via our web portal at the time of requesting the panel, and we will make the records available to the physicians. Meaning the board only needs to organize the records and submit them once, rather than mailing numerous copies, which have been done in the past. Next slide. So based on the information before them, the retirement board can either deny the application or they can request a medical panel at this point. Now I think it's a good time that Natasha, we send them out a question.
Yes, it is. So let's see. Trying to get my mouse to work here. Sorry. Okay, is everyone ready? We're going to give you about 30 seconds to complete this poll. So the question is, a firefighter injured his back while rescuing a victim from a burning building. He sustained a severe, incapacitating, and chronic condition and can no longer perform the essential duties of his job as a firefighter. What type of disability should he apply for? He or she? Okay, but I'm about to close the poll here. Patrice, can you see the results?
I can. So if I'm
And
the correct answer is section 7, accidental disability.
very good. All right, I'm going to turn my camera off.
Okay, so we are going to assume that the board is approving this application to be sent to PERAC for a medical panel. So what happens next? Based on the provision of all the material collected, a 3-member medical panel will be appointed by PERAC. We are looking at the information you provide to make sure that the minimum eligibility requirements are met, that the physician's statement answers the necessary questions, and then determine the type of panel that should be appointed. Next slide. So what are the requirements for forming a medical panel? This could be found in general law, section 32, section 6.3. So who are the medical panel? They're board certified or board certified eligible MDs. They're not financially associated. They're independent medical examiners, and they're specialists in the applicant's condition. So why does it take so long sometimes for some medical panels to form? So there's just a note, just a little side note that I'd like to discuss regarding the pandemic and scheduling. We are currently scheduling telemedicine exams and now joint panel telemedicine exams, along with a limited in-person single exams. It would assist our unit greatly if boards would notify us of the board, employer, and the applicant preference so that we can expedite scheduling. I think you need to go ahead one more. I think you're too far ahead now. Go back 2, I'm sorry. There you go, right there. Thank you, Natasha. So now I'd just like to talk a little bit of impact of the impact of pandemic on the scheduling. PERAC has developed a waiver system for any applicant, board, or employer regarding attending a telemedicine exam during this time. So due to social distancing, it is physically impossible to maintain social distancing and a joint panel. So upon receipt of the waivers, PERAC schedules telemedicine exams currently. If any party does not agree in-person single exams will be scheduled. So now next slide. So now, as I noted earlier, we do have the ability to schedule telemedicine joint panels. The format for the exam will be one physician and applicant in the exam room, and the other 2 physicians will participate remotely. We will require the waivers for all these exams. Again, the boards can assist PERAC moving these exams forward by contacting us at the Disability Unit at 617-591-8956 and let us know what type of panels their applicants want. Next slide. So applicants have the option of a joint or separate exams. I'm going to back up a little bit pre-pandemic and just touch on some scheduling issues we can have that could be related to scheduling. While we have numerous panels that meet regularly around Massachusetts, we also run into difficulties trying to get 3 doctors with the correct specialties to one location at the same time and date if someone chooses a joint medical panel. This factor may affect the time frame from request to panel appointment. Western Mass and Springfield areas are particularly problematic. Even though an applicant may request a joint panel based on their location or condition, this is not always possible and may be required to schedule separate exams. Again, currently, joint telemedicine panels are being performed with the member and the doctor in the exam room and the other 2 doctors remote. Next slide. So who can attend a medical panel examination? Since the principal purpose of the examination is to discuss and evaluate the physical condition or mental health of the member, attendance at the examination should be limited to the member and the medical panel's physicians, the employee's physician, and the employer's physician. The member's attorney and the employer's attorney may attend the exam, and the member may permit the presence of other individuals provided that their presence will not disrupt the examination. This is also stated in the statute. And I am aware that during this telemedicine time that lawyers have dialed in via phone during an exam, and I believe they can participate remotely. Next slide. So let's talk about notification, rescheduling, and no-shows. PERAC provides 14 days notice of the exam to the member, the retirement board, and the employer. So what if the applicant does not go to the exam? A no-show payment will be assessed to the member for $150 for a single appointment and $375 for a joint panel. A no-show will be waived for limited circumstances. We will reschedule for an applicant illness, weather-related conditions, but we do not reschedule for attorneys or others to attend. Next slide. So now the exam has happened and the report is submitted to PERAC. There are 2 PERAC reviews for each examination. We review for completeness. We are looking for an independent medical opinion. We do not review for how they are finding. We are reviewing the reports to ensure that the doctors are following our format and that they answer and support their findings on the 3 questions. A survey is also sent out for every appointment scheduled to the member. If we receive a complaint or negative survey about an examination, we follow up with them individually. If a board has a question about a report or they have received differing opinions, they can request a clarification. Information on clarifications are found in 840 CMR Section 10. The boards send the request to PERAC and we will forward to the physicians. After the first clarification, PERAC will review subsequent requests. Next slide. So after the review is complete, PERAC will forward the report to the retirement board. Based on the complete application, along with the medical panel reports, the board is going to make a decision to either approve or deny the application. So that completes the medical panel process of the application. And hopefully I covered everything that you wanted to know about the application and the medical panel process. I appreciate you listening. And now I'll turn the discussion over to Ken Hill for the legal review of the disability application process.
Thank you, Patrice. I really appreciate what you've done here for everyone. It's not necessarily easy to give a presentation, let alone when the slides were not created by you and when you only have a few days notice. And that's what happened with Patrice here. So thank you again for jumping in and doing this presentation. My piece of the presentation, as both Natasha and Patrice mentioned, is the remand aspect of it. The remand is when the board approves a disability application, then it comes to PERAC for review, and we have to remand it back to the board for some reason. My goal in this presentation is to go over some of the common reasons why PERAC has to remand an application, so that the board can perhaps make findings of fact before it comes to us that can aid in that application and cure it. I'm going to give several examples, real world examples that we have recently done. I want to thank the newest member of the legal unit, Felicia McGinnis, who helped me accumulate a lot of the information on those remand letters. So thank you. And I guess we'll go. Just to back up a little bit, boards can approve or deny applications. If there is a negative medical panel, the board must deny the application. If there is a positive medical panel, meaning at least 2 out of 3 doctors found for disability, permanence, and causation, then the board may approve it, but they do not have to approve it. The Supreme Judicial Court has found that the certification by the medical panel that this incident might have been the cause of the permanent disability is not decisive of the ultimate fact of causal connection. It is in the nature of evidence before the local retirement board. So the board still decides. In the alternative to approving or denying the application, as Patrice mentioned, the board can seek clarification from the medical panel, or it can even petition PERAC for a new panel. Okay? If the board does approve the application, it goes to PERAC, and that's basically what my presentation is going to assume. PERAC's authority to review board grants of disability retirements can be found in section 21(1)(d). Pursuant to this statute, PERAC has 30 days to either approve or remand the application. If we do not do either of those things within 30 days, then it is deemed approved pursuant to the statute. Now, PERAC may remand a disability retirement application for the following reasons. Okay? That it was made upon unlawful procedure. Okay? This is rare, but will be discussed in the presentation. If it was unsupported by substantial evidence, this is by far the most common reason that PERAC has to remand an application, and it will be discussed at length. PERAC can also remand if it is found that the decision was arbitrary or capricious. I have never seen that. Okay? We can also remand if it is a result of fraud or misrepresentation. Again, I've never seen that. So those 2 bullet points will not be discussed in this presentation. Okay, let's look at unlawful procedure. That sounds very harsh. I mean, boards don't like to get a letter from us where we accuse them of breaking the law, okay? That's not what we're doing, okay? It just means that the board failed to follow some sort of procedural requirement, and that's why we have to kick it back. The following slides are going to address some of those reasons why we have to remand for unlawful procedure. Lack of a positive medical panel. Okay, this is the most common reason why we have to remand for unlawful procedure. It's because the board approved the application when there was not a positive medical panel. As the appeals court has found, a positive certification by a majority of the medical panel is a condition precedent to the approval of an application for accidental disability retirement. Okay, so it has to be a positive panel. Sometimes the board will approve an application when there's a negative panel because they think that the medical panel made some sort of mistake. A retirement board cannot do that in most situations. Okay, it has to be a positive panel. They cannot use their opinion basically to approve a negative panel. There is an exception though. A retirement board may decide that a medical panel's negative answer on causation was based on an improper standard in a presumption case only. Okay, that's the only time, and it's very limited. An example of when the medical panel may have used an erroneous standard is if the medical panel attributes the presumption to other factors that aren't really factors. But again, that doesn't happen often. Another reason why we have to remand for unlawful procedure at times is if the application is missing documents. As Patrice mentioned, there are several required documents that must be in an application. That's pursuant to section 6, 7, and 16 for involuntary applications. And if there are documents missing when we do our review, our standard practice is to contact the retirement board and let them know, hey, we're missing this job description. Please supplement. We don't want to remand if they're missing documents because it might be out there somewhere. So we usually wait up until that 30-day requirement to do the remand on these. Another reason for unlawful procedure is if there was a failure to file the application via Prosper. Back in July of 2017, we said that starting in September of 2017, all applications from boards, disability applications from boards must be uploaded via Prosper. We had to remand several early on in that, but since Prosper has been up and going for 3 years, we haven't seen any in a long time, and we don't expect to see many more. An unlawful procedure that comes up sometimes with ordinary disability applications is if the member does not have the requisite number of years of service. Okay, as Patrice mentioned, for most boards, it is 10 years. For 3 boards, they require 15 years still. I won't shame them here, but you know who you are, okay? Now, if we see an application and the employment statement says that the person started working in 2015 or 2012, let's say, and they're retiring now, well, we're like, that's not 10 years, doesn't add up. So we usually contact the board. Oftentimes the explanation is that there was some sort of military buyback or a past service purchase. In most situations, it's best practice for the board to include a breakdown of the creditable service so that there is no delay. Another unlawful procedure reason concerns involuntary applications only. Okay? Involuntary applications are done under section 16(1)(a). Well, they're done under section 16, but specific to 16(1)(a). Okay? It provides that any head of a department who is of the opinion that any member employed therein should be retired for superannuation, ordinary disability, or accidental disability in accordance with blah, 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 may file with the board on a prescribed form a written application for such retirement. Such application shall include a fair summary of the facts upon which such opinion is premised. And then I have emphasis added. There should be an emphasis on that last sentence. I apologize. That should be in bold. Okay? The statute requires that the employer make a fair summary of facts. The employer statement on the form is not sufficient. Okay? We need something in writing from the employer. Okay, summarizing the facts, why they think that the person is disabled. Okay, moving on from the unlawful procedure aspect, the next, and as I said, the most common reason why we have to remand an application is when it is unsupported by substantial evidence. The board must remember that the board is the finder of facts. Okay? It's very important that the boards make findings of fact because oftentimes they can clarify if there's any ambiguity in a member's application. Okay? Oftentimes there is this ambiguity, and that is the reason why PERAC must remand it. Despite what people may think, we do not ever want to remand an application. We want it to come to us so we can approve it. So any help the board can give us by making those findings of fact is greatly appreciated and will help your members. Now, the following slides detail some general categories that fall under the unsupported by substantial evidence umbrella. One of those is remands that occur because the member was not injured while in the performance of his or her duties, okay, which is required by Section 7. There's a whole subset of categories that fall under this. Okay? Those include cases where the member sustained an injury while going to, from, or at lunch or on a break, while going to, coming from, or in a bathroom, while going or while traveling to work or while leaving work. Okay, those are all examples, and I'll get into them a little more. Another reason is if a coworker horseplay is involved. Okay? And another reason is if the person was injured while they were performing a duty outside of their job description, or they weren't performing an actual job duty when they were injured. And I'll get into some of those examples. The first one is the injured while going to, from, or at lunch or on a break. In 1959, the Supreme Judicial Court, or SJC, published two similar cases on the same day. They both involved the Boston Retirement Board versus Crabb. In one case, the member was a nurse who was injured when she left work to go home for lunch. In the other, the member was a stadium matron who was injured while on her way back to work following lunch. The SJC determined that eligibility hinges on whether the applicant was going from a work-related obligation to a work-related obligation. Okay? Neither of those members were found eligible, okay, because one was injured while walking to a non-work obligation. She was walking to lunch, that is a non-work obligation. And the other was injured while she was walking from a non-work obligation. Okay, she was walking from lunch. Okay. If you take away anything from this presentation, take that away. Okay. You need to be going from a work obligation to a work obligation. Okay. That is how you can be eligible. Okay. If not, then you are not eligible. This has consistently been upheld, and the case that's most often cited is the Namvar case from 1996. In that case, the SJC noted that this is strict standard, but it's been around for a long time, and we need to apply it fairly to everyone. And so that continues to be the standard. Now, recently, within the last few years, we've had several incidents that have touched on situations like that. In the first incident, a gentleman had a heart attack while he was eating lunch at home during his shift. Okay, he then jumped in his cruiser and drove to the police station. Okay, we had to remand his application, okay, because he sustained an injury while at lunch, which is a non-work obligation. Okay, his attempt to drive to work did not help his eligibility, however, because he was coming from lunch, which is a non-work obligation. The second bullet point here concerned an applicant who had a stroke while off duty and at home. He claimed that he was in the process of responding to an alarm call, but he had never left his home. He was found not eligible either because he was at home and off duty. Okay, his claim that he was in the process of responding to an alarm call did not matter. Okay, again, because he was coming from his home where he did not have a work obligation. Whole subset of similar cases, okay, involving bathrooms. Okay, I've listed out several of the cases, but in essence, they all say if you're in a bathroom and you get injured, you're not eligible. If you're on your way to the bathroom and you get injured, you're not eligible. If you're leaving a bathroom and you get injured, you're not eligible. What the Doucette case, the second bullet point here, is interesting because in that case, the applicant argued that she followed a colleague, one of her underlings, I believe. She followed that underling into the bathroom to reprimand her, okay, and was reprimanding her the entire time they were in the bathroom while they were in adjacent stalls, and continued to reprimand her as they walked to the sink to wash her hands when she slipped and fell and injured herself. The court was not swayed by her claims that she was doing that. I always think, if that is true, she's just a horrible boss. I mean, give people some peace and quiet when they're going to the bathroom, you know. But that's just my personal opinion, okay? Recently, we've had to do some remands that involved bathrooms. Next slide, Natasha, please. The first bullet point concerned a member who was injured while he was leaving the bathroom and he slipped on a recently washed hallway floor. Okay. In his application, he wrote that he was doing paperwork, decided to go to the bathroom, you know, down the hall, and then he slipped on the floor outside the bathroom as he was returning to his office. Okay. That's what he wrote in the injury report, and that's what he wrote in his application. At the hearing on this matter before the retirement board, which incidentally was 12 years after he sustained the injury. Okay, at the hearing, he testified that while he was in the bathroom, one of his colleagues, a fellow police officer, yelled that he needed help. So he rushed out of the bathroom and slipped immediately as he left the bathroom. PERAC had to remand this application. We told the board that they must make findings of fact trying to reconcile the discrepancies in the description of this injury. We also pointed out he's still not eligible because he was leaving a non-work obligation, the bathroom. The second bullet point was from a few years ago, and this concerned a member who sustained an injury when he slipped while in a bathroom/locker room. Okay. We originally remanded it, and then the board made findings of fact, okay, and sent it back to us. And in those findings of fact, it turns out that actually this bathroom was a locker room. And in the locker room, they had a huge closet where they stored many things, including blueprints. And that this gentleman was in the process of getting those blueprints when he slipped and fell, okay? Now, given those findings of fact, he was in the performance of his duties. He had been going from a work obligation, his desk, to a work obligation, getting those blueprints in the locker room. So he was eventually approved for accidental disability in that matter. Cases involving people that are injured while traveling to or from work. We get these cases all the time, and we unfortunately have to remand a great deal of them. And in our remand letters, we point out to the board, please make findings of fact to help out this application, because sometimes they can. If you're injured while traveling to or from work, the same strict standard applies, okay? You must be going from a work obligation to a work obligation. If you're going to work or leaving work from your home, you are generally not eligible. Oftentimes it's ambiguous as to whether the person's shift had already started when they sustained their injury. So that's what I mean when I say it's important for the boards to make findings of fact to help clarify any ambiguity. Over the last few years, I think it's the last 2 years, we've received probably a dozen applications that involve this situation. Next slide, please, Natasha. The first bullet point, a woman was injured while she was in her work facility, but before she arrived at her station to begin her work shift. In her application, she wrote, something to the effect of, on my way to my station to begin my shift, okay? We were not sure if she was in the performance of her duties because by her own admission, her shift had not begun. She had not gotten there yet. We remanded it back to the board to make some findings of fact to possibly assist her with that application. The second bullet point is very, very common, okay? The member was injured while she was walking to her car in the parking lot. She slipped on ice in the parking lot after her shift ended. What is interesting about this case, though, is the member claimed that after her shift ended, She was walking to her car, not to leave, but to obtain some paperwork that she had in there regarding some union matters. Okay? She was the de facto union representative. Okay? She was going to get those documents and then go back to work. Well, we found that you were on your way to your car at the end of your shift. The fact that you claimed that you were getting those documents and going to go back to work didn't really matter, because you were, well, she was a dispatcher, as a matter of fact. Her job duties was as a dispatcher. Okay, her job duties were not as a union representative. So we had to remand that application. The third incident is a member was injured. In her application, she wrote that she finished up her shift, left work, and was on her way to the train station. Again, going to the train station is not a work obligation, so we had to remand it. The fourth bullet point was a police officer who was injured when he slipped and fell in the parking lot at the station pre-shift. Okay? He had written pre-shift, but he had written also in the process of doing my pre-shift inspection of my cruiser. We found that to be ambiguous, and we we remanded it back to the board and asked them to make findings of fact that that was a standard practice and procedure of the police officers at that station, and that he was, his shift had started while he was doing that pre-shift inspection. We just needed more information on that one. I don't believe we've heard back from them yet, though. The fifth bullet point, okay, the member was injured while she was driving to a training site to start her day. Okay? This training site was off-site from her normal place of work. Okay? She argued that, hey, I was only traveling that route because I had to go to a work obligation. She's correct in saying that, but the fact that she was leaving her home to go to that obligation is what doomed her. Okay, again, when you're at your home, you're at a non-work obligation. Okay, the next bullet point was another one. A person was injured in the parking lot on their way to work. Okay, we had to remand it. The sixth one was a gentleman who was injured. He got into a car accident while driving to work. Part of his job duties was to drive to different sites every day. Okay, and he used an official state vehicle to do that. He argued that he was on duty as soon as he got behind the wheel of that state vehicle. Unfortunately, that's not true. That does not follow the case law. Okay, we had to remand his application because he was leaving his house when it happened. The fact that he was in a public vehicle was irrelevant. Okay. Eligibility also requires that the member was in the actual performance of his or her job duties. Okay, the member must be performing an actual job duty at the time of injury. They must be on duty when they are injured, and there must be some sort of nexus or connection between the member's injury and the actual performance of his or her job. Coworker horseplay. Okay. The seminal case regarding horseplay injuries is the Damiano case. Ms. Damiano was a dispatcher who was injured when a colleague jokingly attempted to put her in a headlock. Okay. Quite an office setting, I know. She was injured and it had to be remanded, and it went all the way up to the appeals court. And the appeals court said that she was not eligible because the injury must be sustained in the line of duty. That is, during the actual performance of the duties that the employee has undertaken to perform on behalf of the public. Her injury was not sustained while in the line of duty as a dispatcher. Okay, horseplay, and this is what the court termed it, horseplay was not part of her duties as a dispatcher. And unfortunately for her, she was denied accidental disability. We've seen some recent cases or recent applications that we've had to deny for similar reasons. In the first case, gentleman was a dispatcher. I don't know why so many cases involve dispatchers, but this gentleman was a dispatcher and he sustained an injury while he was attempting to perform a somersault. Now, at first, when the case came to us, it said that he injured his head as he fell out of a chair. But there were other documents, other witness statements that said he came into the room and he jumped off some sort of bouncy chair and attempted to do a backflip and landed on his head. He sustained serious injuries, but unfortunately, we had to remand it because he was not injured while in the performance of his duties as a dispatcher. He was injured due to horseplay. The second bullet point concerns a laborer who was on a break. They were taking 5. They were out, I think they had been mowing lawns. They took a break, he and a colleague, and they started tossing a football back and forth between each other. He tweaked his back, and eventually it got worse. He could not work any longer, and he applied for accidental disability. We had to remand it. He was not eligible because he was injured while performing a non-job duty, horseplay, tossing a football around. All right, regarding not performing an actual job duty, okay? Again, to be eligible, you must be injured while performing an actual job duty. Now, that's one of the reasons why a job description must accompany an application. Now, as stated earlier, Section 7 requires that the injury be sustained as a result of and while in the performance of one's duties, okay? The seminal case on this is the Connolly case. The Connolly case involved a situation where Mr. Connolly injured his back while he was lifting and changing the 5-gallon Poland Spring water bottle at work. Okay. The court found that doing that, changing that water bottle, was not one of his job duties. Okay. And he did not have a duty to replace the water bottle cooler. And so they denied accidental disability to him. I find this to be a harsh result, honestly. I mean, it may be personal to me because I end up changing the Poland Spring water cooler at work. It seems like every other day. I also think that the people that work in my office come to work dehydrated because they drink so much water. Okay, a bunch of camels working here. But anyway, that's just me. Oftentimes now, job duties say something along the lines of, or any other task, it lists out all the job duties and then it adds at the end, or any other task to further the interests of your employer or assist. There's usually a catch-all that's inserted in those. If there is not in your job description and you're the person that changes the water cooler, I would go to your boss and ask that they include some sort of catch-all line like that at the end. Recently, we've had to remand some cases for similar reasons. Next slide. We had to remand a case recently where an engineer injured his back while moving a filing cabinet. We had another one recently, very recently, where a mental health counselor, he sustained an injury to his back while he was attempting to move a dumpster with colleagues. And another one involved a security guard who sustained an injury while helping someone move boxes. Now, the moral to the story here is don't help anybody move anything, first of all, okay? I'm all for being a team player, but I mean, if you sustain an injury and you're doing something that is not one of your job duties, you are not eligible. Okay? And regarding the security guard one, the employer's statement even said he was not in the performance of his duties. He was helping someone on a loading dock move some boxes, and he was, quote unquote, just trying to be nice. I mean, I hated to remand that one because the guy's just trying to be nice. But the second moral to the story is don't be nice, apparently. Oftentimes we have to remand an application when there is no injury report, okay? Unless the injury was sustained within 2 years of the application must include written notice of the injury filed within 90 days of the injury, or proof of a receipt of workers' compensation payments on account of such injury, or a member not covered by workers' comp and not in Group 1 may satisfy the written notice requirement if there is a record of such injury on file in the official records of his department. Now, what that means usually is if there is a police report, an incident report of some sort, or a fire department log of a call. Okay, those are the official records that we're talking about. Now, PERAC has actually proposed legislation to expand this incident report exception to include Group 1 workers. And the example we use of why it should be expanded to Group 1 workers involves a horrible situation that could occur involving a school shooting incident. Okay, if there's a school shooting incident, the police who respond, and perhaps they subsequently develop PTSD related to that response, well, they can rely on the incident report that concerns that shooting incident. The teachers and other employees at the school cannot rely on that incident report, however. Okay? They would need an injury report. And given that PTSD develops over time, there most likely wouldn't have been any reason for them to have filled out an injury report. Okay? So we want that to include Group 1 members as well as 2 through 4. Okay, what is not an injury report? Affidavits that recount the events of long ago that's written today or more than 90 days after the event. Okay. Workers' comp settlements, newspaper articles, typed or written pieces of paper with no letterhead and no indicia of authenticity. We do receive those at times. We just get scraps of paper that just write out, I injured myself, doing X on Y date. That's not really official. We need something some sort of document that is official looking. And most, if not all, employers have a form that they give when there is an incident or an injury. Okay. Recently, we've had some remands due to that. In the first example, a Group 4 member told the medical panel about several horrible and detailed on-the-job experiences that he encountered that led to him developing PTSD. Okay, he failed to provide any incident reports, however. Now, the incidents that he described, you would be assured that there would be an incident report if it happened. The fact that he did not provide those incident reports doomed his application. He did provide a current affidavit from one of his superiors stating that the member had experienced traumatic incidents during his career, but it was very vague, and the fact that it was not contemporaneous with when those incidents supposedly happened, we could not accept it. The second was a similar matter. The gentleman described horrific incidents that there should be incident reports concerning, but he did not provide any to us, so we had to remand his application. The third is a little different because the member did provide an injury report, okay? But the injury report really didn't say anything, okay? It didn't say how the incident occurred or what he was doing at the time of the incident. Part of the reason being, apparently, he just was knocked unconscious somehow. He doesn't know how, and he can't recall what he was doing. Okay? Neither the board nor the employer provided any additional information to support what he was doing or how the injury occurred. So we had to remand it. We gave the board instructions or recommendations to make findings of fact, to look into this and to determine how it happened and what he was doing. Was he in the performance of his duties when the injury occurred? I don't believe we've heard back from them, however. Another example of a reason why we have to remand on occasion is if the injury concerned a bona fide personnel action. Now, often we see applications where a member claims to have sustained an emotional injury, such as anxiety, depression, PTSD, due to the actions of a superior. Such injury does not constitute an emotional injury for the purposes of Section 7, however, if it arises from a bona fide personnel action, unless the actions of the superior amount to the intentional infliction of emotional distress. Now, bona fide personnel actions can include termination, transfer, reassignment, suspension, demotion, other punishments. Getting to the level of intentional infliction of emotional distress is a very high bar. Okay, the member must prove that the conduct of his superior was extreme and outrageous, beyond all possible bounds of decency, and was utterly intolerable in a civilized community. That's a rather high bar to prove that your superior, was doing that when they, reassigned you or something like that. Recently, we've had a few of these bona fide personnel actions. In the first matter, the member in his application said that he had PTSD because he was told that he was going to be fired. He was going to be terminated. Okay. The application did not say anything else. Okay. At the hearing, he subsequently claimed that there were numerous incidents that led to him developing the PTSD, and that being told that he was going to be fired was the trigger, that all the accumulation of all those incidents, it finally, it was the straw that broke the camel's back. That is under appeal right now, and apparently a decision came out the other day, but I still have not received it. But the bottom line, he did not include any incident reports as well concerning that matter. Okay, there was no allegation that his superior intentionally inflicted emotional distress on him either. So that's still pending, but we'll see where that goes. The second bullet point concerned an incident that this occurred several years ago and actually went up to CRAB. Okay, it involved a police officer who was the court-assigned officer. He worked Monday through Friday, a 9-to-5 shift. He reported to the courthouse every day. That was his job as a police officer. Well, a new chief came in, and he was reassigned to a squad car working the overnight shift. Certainly, I'm sure this was a jarring event for that police officer. I mean, going from a 9-to-5 to overnight shift in a car, I'm sure it was jarring. However, the transfer was permitted and the reassignment was permitted, and there was absolutely no proof that it was done with the intent to inflict emotional distress on him. So he was denied accidental disability for that reason. Another reason we have to remand on occasion is, although it seems obvious, to be eligible for a disability retirement, one must be permanently incapacitated from performing essential duties of one's job. And if you're still working at that job without accommodations, you are not eligible. Frequently, we see applications where, to the question, when did you cease to be able to perform the essential duties of your position, the applicant writes, still working. We also, in employer statements, often see, to the question, when was the employee last able to perform the essential duties of a position? And they answer, still employed or still working. You can't be able to be working if you're incapacitated from working. Okay, so that's basically the point here. And regarding positions that have mandatory retirement ages, in most cases, a member cannot prove that he or she was permanently disabled if they worked up to the last day of work. Okay, that means they weren't disabled. Okay. Recently, we had a situation that touched on that. The gentleman was a building custodian who injured his shoulder in 2012, and he went out on workers' compensation for 2 years. He returned in 2014, and he worked in an accommodated desk job position. He was the supervisor of custodians. He worked that until 2018, when he applied for accidental disability for the shoulder injury. Now, which position is the appropriate position to utilize to determine whether he is disabled? The accommodated position is the appropriate one. The SJC, in the Foresta case that is there, has held that an employer may assign an employee to an accommodated position to avoid accidental disability retirement, provided that the position's essential duties are similar in responsibility and purpose, and most importantly, there is no loss of pay or other benefits. So we had to remand that gentleman's application. Section 7 provides that an applicant's disabling condition must be by reason of a personal injury sustained or hazard undergone. I know that this may sound basic, but sometimes we get applications to us and we're not sure how the person is injured or what body part is injured. And we need more information to try to clear it up. Again, going back to this is why findings of fact are so important. Okay, it would save that step if the board could make findings of fact as to what exactly the injury is. That would be very helpful to us. Recently, we've had 2 remands that have touched on this. Okay, in the first, the injury report, 2 injury reports actually say that the gentleman injured his right shoulder on the date of injury. Okay. His superior, who was present at the time, also wrote out a report and said he injured his right shoulder. In his application for accidental disability retirement, however, he claims an injury to his left hand. There's no subsequent injury report, and there's no claim of a subsequent injury to his left hand. Okay? He attempted to say that the left hand injury was caused when he sustained his right shoulder injury. Given this finding, we had to remand it back to the board, and we asked them to make some findings of fact as to how they can connect this left hand injury to what was claimed to be a right shoulder injury. The other one that we've recently had involved a very confusing and conflicting description of both the member's injuries and how he sustained those injuries. Between the injury report, his application, medical records, numerous stories were told. In some, he mentions injuring his knee and his back. In others, he mentioned injuring his knee. In still others, he mentioned injuring just his back. In some of them, he states he injured, it still is, he says that he fell on his back when he sustained his injury. Others say he fell on his knee when he sustained his injury. Others say he did not fall at all, but that he banged his knee into a piece of furniture. We could not make heads or tails of this application, and we had to send it back to the board, remand it to the board, so that they could make findings of fact as to what was injured and how it was injured. Another type of, or another reason why we have to remand at times is involves common movements. Okay. In the Adams case, which was an SJC case from 1993, the petitioner was a teacher. Right? She claimed that the constant standing, sitting, bending, and walking that she was required to do as a teacher left her permanently disabled from performing her job duties. The SJC held that she was not entitled to accidental disability retirement for such common wear and tear injuries. Okay. They found that the job duties involving common movements done frequently by many humans, both in and out of work, will not be sufficient to establish an entitlement to accidental disability benefits. And we've recently come across some. The first of these bullet points is a remand that we had to do recently. The next 2 bullet points are actually CRAB decisions that are on point. Okay, but in the first matter, it was a security guard who had to wear a belt, with some gear. He estimated that it weighed about 30 pounds. He said that it weighed him down when he had to walk his rounds at the university campus, and that his back eventually wore down and caused him to be incapacitated from working as a security guard. Well, that job duty involved a common movement, okay, walking around. That's frequent to many, both in and out of work. So he was, we did not find him eligible for that and remanded it back to the board. The second bullet point is a similar case, and this is what we relied on in a lot of ways when we remanded that first case. It's a similar case that involves a corrections officer. He claimed that he developed a bone spur in his heel from having to walk rounds and climb stairs while wearing heavy boots and carrying gear at the prison he worked at. Crabb determined that those duties are common movements frequent to many in and out of work, and so he was not eligible. The other Crabb case that is in the third bullet point involved an applicant who claimed that she had to use the phone at work for long stretches of time, and that her neck sustained an injury from the frequent cradling of the telephone receiver between her neck and left shoulder. Crabb found that that is a common movement frequent to many in and out of work, and she was not eligible for accidental disability retirement benefits. Presumptions. As Patrice mentioned, there are 3 presumptions where it is presumed that if you sustain some sort of medical condition, that it's presumed that you received it in the line of duty. They are Section 94, which applies to police, firefighters, and certain other public safety personnel. That says if you were impaired by hypertension or heart disease, it's presumed to be suffered in the line of duty. Section 94A pertains to firefighters, and it provides the same if there's any sort of disease of the lungs or respiratory tract. Okay, it's presumed that you suffered in the line of duty. Section 94B also applies to firefighters, and it presumes that if you have a cancer affecting certain areas of your body, it's presumed to have been suffered in the line of duty. Now, those areas of the body are skin, breasts, central nervous, lymphatic, digestive, hematological, urinary, skeletal, oral, reproductive, or prostate systems, lung or respiratory tract. Only just recently, within the last few years, was reproductive and breasts added to that list. Now, the presumption is not absolute. It can be overcome. Okay? A common reason why it is overcome is that the member has a congenital heart or lung condition. For instance, if the medical panel determines that an applicant under the heart law has aortic stenosis, well, that is known to be a congenital condition. Okay? So it cannot. So that congenital condition overcomes the presumption that your injury was sustained while in the line of duty. Another reason why the presumption is overcome often happens is that the member did not provide proof that he or she successfully passed a physical examination on entry into service, or subsequently passed the physical exam that failed to reveal any evidence of a heart or lung condition. This is very frequent. We come across this. Oftentimes, especially with very senior police and firefighters, there's a claim that the employer cannot find the pre-employment physical. Okay? Well, that's why this statute, though, allows for a subsequent physical. Okay? The statute does not allow for a letter from the chief. Okay? It needs to be either the pre-employment or subsequent to employment. Okay? Moreover, oftentimes the chief letters will say something like, "We can't find it. He would have had to have undergone a physical exam, however." Well, that's not necessarily good enough. Well, it's not good enough, period. Okay, but there are times where we see pre-employment physicals that indicate that the person had a heart or lung condition, and the employer went and hired them anyway. Okay, so the statute says revealing any evidence of a heart or lung condition. Okay, that has been construed quite broadly. Okay, and that can be a reason why we have to remand an application, a presumption application. Another reason why it can be remanded if there is competent evidence that the disabling condition was not suffered in the line of duty. Okay, most often it's, as I said, when the applicant is diagnosed with a congenital condition, but sometimes it's if there are numerous risk factors at play here. For example, if there's a smoking history, if there's a family history of a condition, if there's obesity, if there's diabetes, things that would make that person more prone to a heart condition, let's say. Generally, PERAC does not opine on such things, and we take the medical panel, their opinion on such things. The last 2 bullet points concern the cancer presumption. Okay. Sometimes the presumption can be overcome if the firefighter served in the position for less than 5 years. Okay? The statute requires that the firefighter have served at least 5 years in order to be eligible for the cancer presumption. In addition, it can be overcome if a retired firefighter discovers the cancer more than 5 years after their retirement. Okay, so the statute allows 5 years after retirement, but if you're beyond that 5 years, you're not eligible for the cancer presumption. Now, please note, this statute does not say diagnosed with cancer. It says discovered cancer. Okay, so that can potentially get that retired firefighter within the 5-year period. Recently, again, over the last few years, we've had numerous incidents where we've had to remand presumption applications. The most common is, we see an application under the Hart Law and we have to remand it because there's the lack of the pre-employment physical or the subsequent employment physical. Okay, in today's day and age, it's fairly common for someone to go, if not to an annual physical, if not an annual physical, then perhaps once every 2 years. So there should be some sort of physical exam that can be provided, and if it's not provided, we cannot approve the application. We had one recently where the member was not entitled to the Hart Law because he was diagnosed with a congenital heart condition. That was an aortic stenosis condition. We had one recently where the police officer retired for superannuation. 1 year later, he applied for accidental disability under the Hart Law presumption. We had to remand it because there's no extra 5 years like in the cancer law presumption, okay? But it was unclear that he was incapacitated performing his duties while he was still a member in service. I mean, he worked up until the day he retired. Okay? So as I said on numerous slides before, if you're still working on the day you're retired, you're able to work. Okay? So we had to remand that one back. Another incident occurred. We found a member was not eligible for the Hart Law because the pre-employment physical revealed evidence of heart conditions. The pre-employment physical said that he was hypertensive and that he had high blood pressure. Well, the employer hired him, which is fine, the employer can do that, but he's no longer eligible for the Hart Law presumption, okay, because there is evidence of a heart condition. We had a similar one with the lung law. The pre-employment physical stated that he was a smoker and that there were obstructive lung problems. Again, that is any evidence of a lung condition, and we had to remand it. And the final one that we had that touched on the topic, a member was not eligible for the cancer law because his cancer was not discovered within 5 years. It was based on the records before us. It appeared that his cancer was discovered about 5.5 years after his retirement. Okay. Now, citing case law, I think it was the Connery versus the Revere Retirement Board case, we remanded the matter to the board, and we advised the board to try to provide medical records showing that he had symptoms of the cancer prior to the diagnosis. So hopefully there are such medical records, and it will come back to us. And in conclusion for my presentation, please note PERAC approves the vast majority of applications it reviews. Each application is reviewed by 2 attorneys. Some of the reasons why we remand an application may be resolved at the board level by way of findings of fact. And in fact, many of the remands that I mentioned today were eventually approved following the board making findings of fact. Okay. And that concludes my presentation and Patrice's presentation. I don't know if there are any questions that have been presented to us, Natasha.
Yes, we have quite a few questions, so I'm going to go through some of them for you. Okay, so this one may be for both of you. Both Section 6 and Section 7 in Chapter 32 starts with, quote, a member in service, end quote. Is it true that a member can only apply if they are active members?
Well, we've seen situations where people have retired for superannuation, and when they put in for the superannuation, they put in for the accidental disability at the same time. So there are some exceptions, but on the whole, you must be a member in service when you file your application, yes.
Okay. To minimize clarification, in quotes, can boards submit questions to the physicians before a medical certificate has been issued?
We advise against that. We don't think it's appropriate for the board to try to get the medical panel thinking one way or another. The reason for the medical panel is to have independent voices evaluating the person. If the board pre-submits questions to the medical panel, we don't think that's appropriate.
When you say employer, in quotes, is that the immediate supervisor, department head, or HR director?
It could be any of the above.
Okay. Why can't the board's attorney attend the medical panel exam?
That has come up many times, and many boards want their attorney to be present. However, Section 6.3b is specific, and you can attend, and the retirement board attorney is not listed.
Okay. Does the employer have a right to obtain all medical information submitted by the member, including the medical panel results?
Does the employer have the right to review the results?
To obtain all medical information submitted by the member, including the medical panel results.
For that one, I'd have to look. I don't think it's specified anywhere, and I don't know our position on that. It's really not an employer's place to have to see all that information. It's in the retirement board's issue at that point. I know there have been situations where employers want to see it, specifically in emotional cases, where they think that the member may perhaps be lying to the medical panel, but I don't think that there's any requirement that the employer has access to that information.
Okay, thank you. All right. If all the doctors, not just the majority, give a positive medical panel, the board can still deny the disability, correct?
I'm sorry, could you one more time on that?
So if all the doctors, not just the majority, give a positive medical panel, can the board still deny the disability?
Yes.
Okay.
And Natasha, if I could go back, member in service. Okay. You don't have to be a member in service to file the disability application. You just have to establish that you were a member in service when the incident occurred for which you're claiming the disability. I apologize for misspeaking.
Okay, thank you. All right, next question. Does the 10-year service requirement in an ordinary include military service?
It can, yes. If they do some sort of military buyback, that could be part of theirs.
And this one's related to the all the examples that you gave, all those great examples. What about emptying the recycling while working?
Well, hopefully, as I said, hopefully there's some sort of catch-all in your job duty that says, anything to help your employer. But I personally, I dislike that Connolly decision so much.
Yeah.
But technically, you could be found, ineligible because that's not one of your job duties.
If it's not in your job description, right?
Yeah.
So this one contains an acronym, so maybe you would know it, Ken. If the member sustains an MI in the performance of duties, while in the performance of duties, but the symptoms do not manifest until he or she is off duty, is ADR precluded?
It would depend on the situation there, but by MI, I think they mean a myocardial infarction or heart.
Okay.
So they're saying the symptoms did not arise until after. Well, I don't know how the person could prove that it happened while they were on the job. So I do not think they would be eligible.
Okay.
Again, it's all fact dependent though. So I'm just speaking generally, I guess, without knowing all the facts.
And this one's more of a comment. I believe this bathroom standard could change. When I have a visitor in my office, I wash down all surfaces that were touched and then go to the restroom to wash my hands so that I minimize the possibility of spreading potential COVID germs.
You know, I actually thought about that in making this presentation. I thought that, you know, I think it's probably likely, I agree with whoever wrote that comment, that at least someone will argue, I was in the performance of my duties. I was doing a job duty for my boss, which was to keep my workplace space clean and prevent COVID germs from going throughout the office. I can see someone making that argument in the future. Whether it is sufficient to overturn NAMVAR, I don't know, but it is a strict standard, and as NAMVAR said in '96, it's been going on for a long time, and a lot of people have been denied ADR because of it, and it wouldn't be fair to start allowing people now.
Mm-hmm. Okay, next one. With staff across the Commonwealth working remotely, what if someone was working from home, headed into their office for some reason, and was injured on the way? Would that fall into the Section 7 category?
If you're injured while at home, it would not. Even if you're doing work at your computer, I can't see how it would be, but I do envision applications regarding that. There are just so many people working at home. Someone's bound to be injured. Be prepared, boards. You're going to see them, but I would say on the whole, I don't see how that could make you eligible for ADR under Section 7.
Okay, we still have quite a few questions to
Oh.
go. You thought you were done.
It's such a relief
Okay.
to be done, but I'm not done.
Oh, this is where it gets interesting. Under Remands section, what if an employee is to attend a work conference and must leave from her home to a conference? Would they have to leave from work?
Yes. Yes. And in many cases, I'd advise that. Go to the office first, pick up some of the documents, and then go to the conference.
Mm-hmm.
That would be a work coming from a work obligation, going to a work obligation.
Mm-hmm. The disability application says, I signed this application under the penalties of perjury. What are the penalties? If a member lies about how they injured themselves, then why isn't there any or some kind of cost or penalty of some capacity?
I mean, are you thinking, I don't know if they're talking about like criminal charges or lying under oath, but I don't know what kind of penalties you could have. I mean, if the board finds that the person lied under oath, then they can certainly use that against the person, and when they make the determination of whether to grant or deny the application. But in terms of criminal charges, I don't see that happening.
I think you kind of answered this one in your don't be nice and don't be kind statement, but what if the boss tells you to do something outside the essential duties?
Well, we had a case recently that there was a gentleman that was he was plowing, okay, and he was plowing with a huge vehicle. It was like a dump, you know, some sort of payloader, okay, and it broke down. And his employer came over and said, you know what, I'm going to tow you. Like, I just strapped a chain to it, and he said, you stay in the back there, and, you know, put your foot on the, you know, you use the brakes and, you know, and the clutch, and I'll just pull you and we'll go back. Well, again, his boss told him to do that. Well, it did not work out well, okay? And he crashed into a tree and sustained serious injuries, okay? The fact that his boss told him to do that did not help him, okay? He was found to it was found to be willful misconduct on his part, because it's illegal to be in a vehicle that's being towed, okay? So I would just analogize to that. You know, that guy, his boss told him to do it. He did it, sustained an injury, but not compensable.
Mm-hmm. And
Natasha, I'm sorry, if I could go back. Thankfully, I work with nice people that are texting me for all my wrong answers, you know. Regarding the question that came up about the employer getting access to all the documents, 840 CMR 10.12 states that any party—
they're giving you citations. Go ahead.
Any party after a hearing has been requested can review any document in the board file, and an employer is considered a party. So the employer does have access to any of the documents in the file.
Okay, thank you. And thank you to your colleagues for clearing that up for you.
Thank Patrick Charles.
All right, let's see. So replacing the water bottle would fall into any and all duties assigned if that were in your job description. And if it's not,
I would say,
then it would not.
yeah.
Okay. A question about the timing of the remands. Are these cases being remanded before medical panels have been convened?
No, no. This is when the medical panel, the board requests the medical panel. The medical panel gives their certification and narrative. The board votes whether to approve or deny, and the board approves it. Then it goes to PERAC, and we have 30 days to either approve it or remand it.
Okay, thank you. Concerning accommodations of duties, must the accommodation of duties be a permanent accommodation, and how does the board know that?
It does not need to be a permanent accommodation, and oftentimes it's not. I believe, well, corrections officers are a little different, but I believe they only permit 180 days, I think, for an accommodation. So it doesn't need to be permanent. How would a board know? I don't know when the application comes in. I assume they would have to talk to the employer when they ask for the job description, and hopefully the employer sends the correct one, which would be the accommodated one. I don't know how they can double check that though, unless the applicant tells them, hey, I was doing a modified job duty.
You're breaking up a little bit, Ken.
Oh, I'm sorry. So
can you just repeat the last part? You were breaking up.
Sure. I'm not sure how much I missed, but the employer should send the job description. And if someone's in an accommodated position, the employer should send the accommodated job description. If they don't, I don't know how the employer can check, other than they should confirm with the applicant themselves that, is this the job description you were performing? Or, you know, are you in an accommodated position?
Let's see. And if an employee refuses to accept another job with no loss in benefits or salary, is that employee eligible to apply for a disability?
They can apply.
It is not an accommodation, but a different job.
They can apply, and their chances are pretty good of getting accidental disability, even if they you know, refuse to accept it, to be honest, based on, you know, what I've seen.
Why would the cancer presumption not be allowed if in the position less than 5 years? This is referencing page 63, bullet point 4.
Sure. I mean, Obviously, that's in the statute, so that's what the legislature determined. I can only, give my opinion on why they would do that, and I would think it's because perhaps, I'm not a doctor, perhaps cancer is, forms over a slow period of time, and that, you wouldn't catch it from hazardous and toxic substances common to firefighting unless you had been exposed to it for greater than 5 years. That would be my assumption.
Okay. The Prosper system does not allow the upload of files greater than 15,000 kilobytes. This will be a question for IT. So can this be increased because some records are extremely large? So for the attendees, we will reference that question to IT. Put in that request. Can a board deny a disability application prior to scheduling a medical panel if someone fell on the way to the bathroom?
Yes.
How will cases be determined if the situation involves an accident while working at home due to the pandemic?
As I said, I would say that someone is not eligible for ADR for an accident that occurs while they're working at home, but I anticipate we will certainly see many applications where people attempt to get accidental disability retirement for such an injury. I just think it's likely. I think it's likely that someone's going to get injured for real while they're at home, and that would be the test case.
Yeah, we had another similar question, so I pretty sure we'll see a lot of that in the future. If a member's attorney submits medical records, is it recommended the board still requests records from the same medical providers?
Yes. Patrice, would you agree?
Yes.
It said, another question is what wording should be in the job description? Anything to help your employer?
Oh, that was just, something along those lines. I don't know exactly how it should be, but any task to assist with the smooth operation of your office, something like that.
Quite a few asking about the working from home. If someone falls on the way to the bathroom, can they file for ordinary disability?
Yes, if they're permanently incapacitated, they can apply for ordinary.
Does being offered an accommodated position preclude a member from qualifying for an ADR?
No.
I think that was asked. No,
Yeah.
okay. If a firefighter is sent to fix a flagpole, it was very specific. A firefighter sent to fix a flagpole with a ladder truck and falls, would it be covered?
It's very specific, but I would say it most likely would be. That's in a situation where the board would really need to make findings of fact, though, to either support the application or to, deny the application.
Yeah. What is considered reasonable medical treatment? If an applicant can have their injury cured by an operation, are they required to have that operation?
Yeah. Dalla and Crab, and actually, going up to the Superior Court as well, and I think the Appeals Court, they're very reluctant to require someone to undergo surgery. We've seen situations before where someone is like, a doctor finds, what, if he has back surgery, he'll be fine and he'll be able to keep working. Well, not everyone wants to undergo back surgery. So the courts have been very reluctant to find that someone has to get surgery. I mean, if it's very minor surgery and they refuse to get it, then perhaps they'd be successful. But most surgery there's inherent risk in any surgery, and a lot can go wrong. So again, courts are very leery to enforce the surgery requirement.
What happens if a treating physician has retired and medical records were lost due to fire?
I mean, if they're lost, I mean, you can't remake the records, I guess. I don't know is the short answer on that one. There would have to be sufficient documentation for the medical panel to make that determination, though. And if they claim that there are no records, well, I would look into that first, that there are no records. And because with, the scanning of documents right now, there could be an electronic copy of that record. So I would definitely look into it. I wouldn't take someone's word for, there was a fire or my dog ate it or something like that.
Okay.
But the medical panel would have to, make the decision based on what they have. And if there's not medical records, I mean, that could either harm or help an applicant.
And just the final few questions. Could you repeat the 3 things listed on the slide about performing duties, on duty, and related to their job?
Try to.
And then while you're looking for that, I don't know if this will throw you off if I ask you another question.
Well, actually, I have that slide.
You have it? Okay, great.
The member must be performing an actual job duty at the time of injury. The member must be on duty when injured. And there must be a nexus between the member's injury and the actual performance of his or her job.
Great. All right, and firefighters. All right, questions are still coming in and we're about to wrap up. So I'm going to take 2 more questions and we will close this out. Firefighters while on duty and in their uniforms are collecting funds with the firefighter's boot for muscular dystrophy, and one is injured or hit by a car. Are they eligible for AD?
I would say no. I mean, collecting money for muscular dystrophy, although it's a noble thing, it's not part of a firefighter's job duty.
All right. Is the 180-day requirement to complete a disability application still relevant? It seems most applications always take longer than 180 days.
That's what the statute provides. I wouldn't say that it's irrelevant. That is the law, but I agree that most applications do take longer than that. We receive a lot of letters from boards seeking extensions on that 180 days, and provided there's a valid reason, we generally agree to that extension.
Great. Okay, so thank you. Hi, everyone. So we have just a couple of comments for you guys. Kudos to you all for a very helpful presentation. So thank you, Ken and Patrice. And I just lost the last one. Great job, Ken and Patrice, under intense questioning. So
Thank you very much.
Good job, Ken.